ಸರಿಯವ. ನೋಡ್ದ ಆಗ್ಲೇ ಬಂದ್ಬಿಟ್ಟಿದಾರ ಆಗ್ಲೇ.
Good evening, sir.
ಗುಡ್ ಈವ್ನಿಂಗ್. Can we start now? Hello, all of you. Can you hear me?
Yes, sir.
Yes, sir.
Yes. So we will start now. Okay, it's 7:05. We will start. So we are discussing the chapter number 7 called the gifts from section 122 to 129. This chapter is very, very important for your examination, and they are going to ask questions from this. A gift is a wonderful topic. When the moment you hear the word gift, it will bring some smile on your face. Gift is there in the life of we, the human beings. We have some loud people, affectionate people, cordial people. On some occasions, we want to make them happy. We want to show our honesty with them. So, we do make the gift. Generally, in the younger generation of 20, 21 years of age, you have lot of feelings, lot of, likes. You have a lot of planning, desires, dreams. So many things you will be having. And along with these dreams, you have this concept of gift. So let us understand today's topic, gift. Section 122 defines the word gift. In simple words, gift is the transfer of ownership of a property to other person freely, voluntarily, without consideration. Or gift is the transfer of ownership or passing of ownership from one person to another person without an expectation, without any benefit, without any selfishness, but there is the presence of love, affection, natural love and affection. So transfer of property, transfer of ownership made with the presence of natural love and affection is called gift. Okay? In our day-to-day life, consider father, he loves his daughter. Father is having that much of closeness, attachment with the daughter. And if the daughter achieves something in her life, then father will be the most happiest person. And father is going to give some gift to the daughter according to the status, according to the love, affection, cordiality, etc. Even the mother who is loving her daughter or son, she too may contribute something, she too may gift something to the daughter or to the son. Or consider there are two good friends and they are mutually love and affection showering to others. So, a good friend can also be giving some gift to the other friend. So, what are the essentials of gift? What are the essentials of gift? First one, the parties. So, there are two parties in a gift transaction. One is called generally the owner of the property, and he is the transferor. He is going to give it to other person. So that transferer is called the donor. And the one to whom the gift is being made is called the donee. Generally, the donor must be of the age of majority, must be of sound mind, must be the absolute owner of the property, and the opposite party, that is the donee, may be a major or a minor. Even a child can receive the gift. Even a major person can receive the gift. So the donee can be a person of majority or minority. So the donee is the receiver of gift. Donor is the transferer of gift. Second essential, subject matter. Here, he explains, he covers both the movable property and the immovable property. All the movable property can be the subject of gift. All the immovable property can be the subject of gift. So, both properties can be the subject matter and it can be transferred from one living person to another living person. So, subject matter, movables and immovables. Third essential, consideration. There must be natural love and affection. You know that mother's love to her son or daughter, or father's love to his daughter or son, or the love of a husband towards his wife, and the love of wife towards her husband. Love of a brother and sister, love between a boyfriend and a girlfriend. Love of a master towards long time, honest, sincere, domestic servant. Recently, I came across a chef in the White House where the chef is sufficiently aged person, is around 70 to 80, and he, with honesty, served number of presidents of America. For 30, 40 years, he has served. And he was a wonderful cook. And every president of America had a piece of love for that great chef. So, A master can have natural love towards his long serving, honest, sincere servant. Natural love and affection is the only consideration in the transaction of gift. There should not be any benefit, any expectations, any kind of other uses will destroy the validity of the gift. So, whatever may be the relationship, father, mother, husband, wife, brother, sister, friend, or a master and a close servant. In all this relationship, we come across the word natural love and affection. I would like to give one small illustration, and you have to decide. You know, when you are 20, the whole world looks beautiful, green, attractive, colorful, so many things. Consider there are good youth and also bad youths. Consider one such youth who is influential, who is having lot of money, who is having lot of property, who is having lot of energy, who is having lot of youth. One day, he saw or she saw a fair person. Both sides I'm using the word. He saw or she saw a fair person. And that youth have told him, why can't you spend some time with this person? Why can't you have some fun with this person? I'm having lot of money, that this fair person can be attracted to me, or I can attract this person by my wealth, by my money, by my power. So consider, this youth says that I want to transfer this much of benefit to you if you could spend your time with me. And the opposite person, that fair person, agreed to spend the time with this man or with this woman. Now the question is it a gift? Is it a valid consideration or not? One person giving some money, giving some jewel, giving some benefit to the other person to have his company, to have some fun. Now, will this transaction be considered as a gift? Is it a natural love and affection, natural cordiality, natural humanity? Is it a valid gift or not a valid gift? I think all of you are very well versed with the Bollywood heroines. Do you? Can you, 4 members, tell me, can you name at least one heroine's name?
Aishwarya. Yeah.
Aishwarya, very good. Next.
Alia Bhatt.
Latest. ठीक है. Next.
करीना कपूर.
अरे यार, वो अभी हीरोइन है क्या?
यस सर, अभी भी है.
अभी भी है, अभी वक्त है.
Sorry, sir.
अच्छा 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 अच्छा. हाँ, next one, tell me.
Jacqueline Fernandez, sir.
Oh yes, oh yes. Do you know one heroine, very tall heroine? She was also Miss India or Miss India.
Shushmita Sen.
Ah, very good, very good, very good. Shushmita Sen, so good. Can you take one leaf from her life and connect it to this topic, gift? You know Shushmita Sen, a day in her life connected to this gift. Who has given her something big a gift? Who is that person or who was that person? Can you call it as a gift or not? You know that person. No? Nobody knows?
No, sir.
No, sir.
Oh yes. अरे यार, आजकल तो सब लोग तो एरोप्लेन को बनाने में जुटे हैं ना. There are two brother industrialists in this country. Can you name them?
Ambani.
हाँ, दो लोग हैं ना.
Mukesh Ambani and Anil Ambani.
हाँ, तो बड़ा कौन सा है, मुकेश या अनिल?
Mukesh.
Mukesh.
मुकेश, very good. What about Anil bhai?
He's the younger.
Younger. Okay. Now this telephone man is going to repair our raffles. Right?
Yes, sir.
Yes, this person. So, you know, when you are a small child, your father, if you had a grandfather, used to tell a story. There was a town, there was a kingdom, there was a king, there was a queen, there was a forest, like that. So let us tell a story. There was an Anil Ambani. And this fellow once saw Shushmita. And this man was attracted to the magnet. Dilbar, kuch hota hai na, bahut kuch hai na. So one day, you know, they are all business people, and one day they had an agreement. They combined together. They came to an understanding. And one day, Mr. Anil Ambani has given some wonderful gift to Shushmita Sen. But you, as a law student, you have to tell me, is it based on natural love, affection, cordiality? Or is it a gift without any expectation of any kind of benefit? Or is it a transaction with mutual benefit? If it is mutual benefit, it cannot be called as a gift. If it is a pure benefit to one person on the basis of love and affection, it is called as a gift. How do you feel about this? Can you call it as a gift or not? I want all of you to speak.
No, sir. If any kind of condition is attached to any kind of gift, then it cannot be a gift because it has to be like
Given
it
voluntarily.
yeah. It's like then in that case it will not be just a gift.
No, such a big person has given something to Shushmita. So we can't call it as a gift, is it not?
If he is giving voluntary without any expectation or without any consideration or without keeping any terms or any kind of agreement as such, then it will be a gift. But if it is done with an intention of getting something back, it can be anything. Or if it is a term like, okay, if I'll give you this, or you work for me, or you do a branding for me, then it will not be a gift.
Very good. Same thing has happened. Yeah, you are all young. You have a lot of knowledge. You have lot of general knowledge. Okay. अरे यार एक दिन तो मेरे साथ आ जाओ ना. Mr. Anil has told Shushmi Madam ji, and that cannot be a gift. He gained benefit from her. There is no presence of love and affection. There is the presence of lust, bodily attraction. So, gift should not have lust. It should have pure, sheer, natural love. Okay? So, consideration. Another essentials of gift, acceptance. I told you that in India, Hindu laws, there are two kinds of schools. Dhayabhaga, practiced in state of Kerala and West Bengal, and Mithakshara, school practiced all over India, excluding these two states. Dhayabhaga school says, state of Kerala and West Bengal, they have common understanding. They says, gift is free. Every man presumed to accept gift. He may express the acceptance, or he may not accept, he may not express the acceptance. Acceptance may be there or may not be there. Gift is a valid transfer of property. That is, Dhayabhaga says. But the other school, Mitakshara, says, no, for every gift to be a valid gift, one person has to give and the other person has to accept. And the acceptance must be open, must be seen to others. Without acceptance, that cannot be called as a gift. So according to Mitakshara, the donor has given the gift and the donee has not accepted the gift. He has rejected the gift. Then it cannot be considered as a valid gift. Mitakshara says, there are people who do not want to take anything from any other person. They have a dignified life. They have a self-respecting life. They don't want to touch anybody's property. So, in Mitakshara, if the donee does not express his acceptance, then it cannot be considered as a valid gift. Right? So, these are the essentials of the gift. Now, they will ask you a question. How to make the gift or how to transfer the gift? Section 123. Let us analyze slowly. I'll give you 1-2 illustrations and your mind should be present and you have to tell, is it a valid gift or not? Consider Mr. A is having true love to Lady B. Mr. A is having true love to Lady B. Out of love, affection, on the birthday of a lady, Mr. A gave a diamond ring to her, saying, God bless you, happy birthday. The lady accepted it. And she said, I'll never forget this gift. It's wonderful. It is just like your personality. So she has accepted in both the hands the gift given by Mr. A. Apply and tell me, is it a valid gift? Is it a valid transfer or not? Pure common sense. Is it a valid transfer? Is it the proper method of gift or not? Tell me.
Sir, I think it can be referred as gift because first of all, it is made voluntary. Plus, he like at the time of gifting, he has not kept any kind of consideration,
Mhm.
and also it is like voluntary accepted by the person who is receiving it.
Okay.
In these
Okay.
three conditions, as it is present, so I think it will be a valid gift.
Oh, yes. You got the question? Whether the transfer, is it proper, is it effective, or is it going to give rights to the donee on the property?
So it,
Whether the method of transfer, is it acceptable, is it lawful or not?
sir, it is a movable property. It is a kind of movable property.
Uh-huh.
And if it is given, like, with his consent, like the consent or willingness of the donor,
Hmm.
and if there is nothing, no condition, nothing is attached, it's just mere a gift because he is just wishing him that God bless you, this is a gift for you, without keeping a consideration that, okay, I'm giving this gift and please marry me or become my partner. Nothing is said or attached to this particular thing. Then I think it can be a valid gift.
Oh, yes. That diamond ring, is it a movable property or an immovable property?
Movable property.
It is a movable property. So what we can analyze here, if a person is the absolute owner of a movable property and he wants to transfer it to other person as a gift, it is a very easy process. He can simply bring that movable property and hand it over to the donee openly, lawfully, peacefully. Here, the delivery of possession of movable property will be an effective transfer of property as a gift. Just giving the possession of the diamond ring to the opposite person is a valid transfer of property or an effective mode of transfer. That means there is no necessity for showing the transfer of diamond ring on a stamp paper. The transaction need not be in writing. The transaction need not be registered. The transaction need not be witnessed. Simply, the absolute owner delivering the property, movable property, to the opposite person with complete mind of passing its ownership out of love and affection. Such an act shall be called the lawful transfer of gift from one person to another person in case of movable property.
So I did not get, why did you mention about like writing of something, like if he is transferring, do he have to write it and give it to her, or he can directly transfer that diamond ring to the lady?
Coming to that part, consider it's a very, very costly ring. And that person might have created a stamp paper. There, he has explained all the details. He has explained all his detail and also the details of the donee. And there he has mentioned that this gift I have purchased for the purpose of donating it or giving it to the donee from such and such an office or from such and such a jeweler on this and this day. I have purchased this lawfully out of my own hard-earned money or something like that. That can be done. That kind of writing can be done. But law says, in case of movable property, it may be of a very high value or a low value. There is no necessity of the writing a simple transfer, handing over of the possession to the other person will be considered as a valid transfer of gift. This is one point. Now coming to the transfer of gift of immovable property. Every transfer of immovable property of value of rupees 100 or more must be by means of stamp paper and must be registered. I'll give you two illustrations and very carefully you have to, because they will ask you this kind of illustrations in the exam. Okay, very carefully you follow. First one, first illustration. Consider there is a man called Mr. A. He is the absolute owner of a house. A is the absolute owner of a house. Very carefully, you have to analyze. I want to examine your psychology of understanding. So Mr. A is the owner of a house. Mr. A is having a sister. We'll call her as B. Mr. A is having lot of love, affection on his sister. So A is the brother and B is the sister. A is the absolute owner of the house. A is having lot of love and affection towards the sister. One day what happened? This brother, Mr. A, he was having that much of love and affection. He created a gift deed of his house in the name of his sister. Gift deed he has prepared on the lawful, proper, adequate stamp paper. So he has called upon two witnesses, lawful witnesses, Okay, he went to the office of the sub-registrar. He has paid the fees there. He has taken the receipt of that one. And then the sub-registrar told him, you come after 1 week. You come after 1 week. I will give you back the registered gift deed. Sub-registrar was good. He said, I have so many things to do. Okay, so you please come next week. I will make all the entries in my official book. Okay, then I will put all the seal, signature, and all the other details. Then I will give you this document. So what happened? Mr. A deposited or delivered the gift deed with the sub-registrar. He has paid the governmental fees, and then he came back to the house. Next day, this matter came to the knowledge of a relative. You know, we have a tongue, a beautiful tongue with poison. We will poison the mind of others. And there are so many reasons to poison the mind of others. So what happened? One of the relative poisoned the mind of Mr. A and told him, why you have transferred the house to your sister. She is not a good person. She is a bad lady. She don't have trust in you. She hates you. So many things as garbage was filled into the mind of Mr. A. The brainwashing was so beautiful. Mr. A decided, yes, I should not give the property to my sister. Slowly, he all alone came to the office of the sub-registrar. And he requested them, sir, don't register that document. Give me back that document. The registrar said, no, I can't give you the document. You please come after 1 week. I will get you this document. There were no other person. This Mr. A killed that registrar, sub-registrar, and took away his original document. Now you think whether the gift has been made to the sister, is it sustainable? Is it a valid gift? Or is it not a gift at all? Apply your mind, all of you. Come on, give me the answer. I'll give you 2-3 minutes of time.
Excuse me, sir.
Yes, Lavin.
Sir, due to some network issue, I was unable to understand the last part of the situation. So I wanted to make a confirmation. Like, did you said like he cancelled the registration to gift?
Yeah. Any others? Any others can supplement him?
Sir said that when the third person said bad about or brainwashed his mind and said that the sister is not of a good nature and you should not transfer the gift, he went to the registrar and he asked his documents back, the original documents back, but the registrar said that please come after 1 week and by then he will make that the deed is ready. Then he's like, no, I want my documents back. And that time he killed the registrar and took his original and came back. So sir is asking, is it a valid transfer of a gift?
Apply your mind, common sense. Think in different angles, then come to a. Once this illustration has been given, and they have asked, decide, is it a valid gift or not?
Sir, what I feel here is in gift, they say that it must be voluntary, first point. And then, even if there is house, which is an immovable property and which need to be registered in most of the cases. So, here, I don't think there is any kind of registration took place because before that like I will just ignore the fact that he has killed the registrar. Like when question is there when it is a gift or not, I'll consider that uh, the registrar is the only person who can take care of the registered deed of a gift also. So if he's not having the valid document to register that gift deed, so the register is not complete. So if it is not completed, because he before completion he collect the Mr. A has collected all his original document, and also now he doesn't want, like because his mind is brainwashed and he doesn't want to gift that property to her sister. I don't think it is a valid gift.
Oh, yes.
Because
Others?
and also the sister is unaware about the fact that the brother wanted to gift something, so even sister can't come and claim that you promised me that you'll give the gift and now you're not giving. So in this entire case I don't think it is any kind of gift deed is created or it is a valid gift.
Oh, yes. Yeah. Good, good, good. Come on. Any others? Others?
So same reason, I think Mansi said right, and the main highlighting reason was the part where the registration process was not complete on the name of the person's sister,
Mm,
which was
mm,
supposed to be done so as
mm.
to provide her as the property as a gift. So as the registration was not done, so it is not a
Mm.
valid gift, I think.
Okay. Others? Okay. I told you. See, there are few good lawyers in our country. Very few. And some of them are wonderful thinkers. They analyze so beautifully. You did catch when Mr. A submitted the deed to the sub-registrar for registration. What is the meaning of that? Can he go all alone and submit for registration?
No,
For
sir.
every registration, there has to be two parties, the donor and the donee. There has to be a minimum of two witnesses, right? So Mr. A went with his sister B and also two witnesses to the office of the sub-registrar. They have purchased the adequate stamp paper. They have typed it out, all the things, or they have handwritten it, all the details, and there is signature of the two witnesses in the presence, in the direct presence of the sub-registrar. There is a signature of the donor and the donee in the presence of the sub-registrar. Then the house submitted this document by paying the governmental fees. Governmental fees is there, paid. Document is submitted to the sub-registrar. Then, once the document is delivered to the sub-registrar, there commences the official activities, official action, lawful action on the part of the sub-registrar. Once the sub-registrar has accepted the document with the governmental fees, after the signatures of both the parties and the witnesses, such a document, even though it has not received the seal and signature of the sub-registrar, is considered as a valid, registered gift deed. So, in this case, in this illustration, when it was challenged, the court held Mr. A is no more the owner of this property. His sister B has become the owner of this property. Registration is complete, even though it has not received the seal and signature of the sub-registrar. There is a book called Mullah. You have to go and find a book which is about 20, 30-year-old mullah. There you have to open this section 123. There are so many such cases, such illustrations.
Sir,
Yes, ma.
but I just want to add, I'm like not contradicting your point,
Okay.
but when you talk about lawyer, right? So the point which is given in this particular example or what you quoted is we can see it as favoring the sister, saying that okay, everything is done, all the transaction or sorry, not transaction, all the attestation is done in front of the registrar, everything is there, fine. But sir, when we will talk about gift as a whole, so the very first contention of the gift is it should be done voluntary, right? It should be your voluntary act with your consent. So if we will talk about consent, which is willful consent or free consent, then I think section 14 of Contract Act will come into existence, because that time he want to give, now he doesn't want to give. For example, if third party has not said him bad about his sister, and for example he came to know something about a bad deal or a bad nature of her sister, and then he realized okay, I should not do it. So if he is not willing to do that, and if he is owning that property, plus it is an immovable property, so I think this will again be a art of a lawyer in the side of the brother to prove that he doesn't want to give it now, and it will not be considered as a valid gift because he is not doing it willfully and he did not want to do it at the first place. So I think it is again, it's like who does best arguing will win the case, because if we have to get points in favor of brother, yes, I think we can make points for him as well.
Okay. Tell me how many times a person wants to marry.
If it is not working, they want to marry, like yes, they marry n number of times also. But yeah, it should be valid marriage, valid as in he should divorce the wife, earlier wife, and then he can go for another marriage.
Yeah. Remember, when brother has created the deed of gift, with lot of love, affection, cordiality. He wants to do something good to his sister. It was natural. And this making of gift is only once. It cannot be twice, thrice, 4 times. No, only once. Once the gift is made, there ends the matter. Afterwards, you may come across any number of bad things about the sister. Now you cannot. You cannot take it back. You sense you can only make gift once to your sister. Once you have gifted, you cannot take it back. Right? So here, the court said simply this much. Once Mr. A has delivered the gift deed after paying the governmental fees to the possession of the sub-registrar, there ends the matter and the deed is presumed to be signed and sealed by the sub-registrar. It is a valid gift deed and the sister has become the owner of that property. The brother, Mr. A, he don't have any right to take back that document from the possession of the sub-registrar. It was a complete transfer of gift in favor of the sister. Okay? So our analysis is on this much. Registration is a must. And the document which is given to the registration, to the possession of sub-registrar, is considered to be a valid registered document, even though it is not signed and sealed by the sub-registrar. Got the point?
Yes, sir. But yeah, okay.
No dusra shadi. Only once. Before you marry, think 100 times. Okay, in all the angles. Only if you like, you proceed. No other things. Okay.
Yes, sir.
Okay. One more illustration. Some of you may be 4 members today, and some of you may not to hear about God or goddesses. It depends on you. One illustration is like this. Some big actors of our country.
Excuse me, sir.
Yes.
Sir,
Bolo,
if you
Lalit.
are scrolling your screen, so I'm unable to see because it's stuck on section 123. If you are scrolling the screen.
No, I'm not scrolling. It is there. It's there, that much. Because only one section I have to explain a lot. Okay.
Okay, sir.
Okay. So it is there stagnant. No, don't worry. Okay. One biggest hero of our country visited a temple. A very big temple. And there he said, from this moment, my land shall be the land belonging to this temple. I have gifted my property to this God. And you know, if the big hero, even if he is having a nose running, it will be a news. And when this big hero told to the world, I have transferred my property as a gift to this God. Oh, wonderful thing. And all the news channels have started showing it. Here in this illustration, he openly told that this is the property of God. From today onwards, I don't have any right on this property. And that fellow has only prepared a white sheet of paper. There he has signed. There he has two witnesses and delivered it to the temple authorities to show his sincerity, honesty, that he is really interested to give this property to the temple. Now you decide, is it a valid transfer of gift? Is it a lawful transfer of gift? Whether the temple has become the absolute owner of the property of the hero or not. Apply your mind and tell me.
Well, it's saying the temple or any kind of a idol. Like your question talks about only a temple or like any kind of idol. Why I'm asking this, because I have read somewhere in some cases that the idol or any god idol is considered as a juristic person also.
Very
That's
good.
why, that's why I'm
Very
asking.
good. Very good. Good, good, good.
So it's like if he is a juristic person, and which means he is not a living person, but yes, a gift to any kind of idol. It does, the act doesn't talk about it that a gift made to the idol is valid or invalid. It doesn't talk about it, but I think a person can do that, and for that registration is not required. They don't have to register that property, but I think they can make a gift in favor of any kind of idol.
Okay. Indian Registration Act 1908 says, documents which needs to be compulsorily registered. Documents of those properties, especially movable properties, of value of ₹100 or more, must be in writing on the stamp paper, must be registered, must be by means of paying the charges of registration to the government. And only then it will be a valid document. The registered document gives rights, responsibilities, liabilities, duties to the parties. If it is not registered, they do not get any kind of lawful right on the property. So every transaction of sale, mortgage, or gift, or exchange, or settlement of property, everything must be registered.
Even if it is for an idol or a temple?
Yeah, wait, I'll tell you, that's what. Please refer section 3. Transfer of property from one living person to another living person. Living person means and includes the human beings and all legal entities, juristic persons, legal personalities, such as temple, church, mosque, universities, companies, associations, firms. So many things will come under the concept of legal personality or juristic personalities or legal entities. Temple, church, or mosque registered will come under the definition of legal entities. One human being may transfer his property as a gift to these legal entities or vice versa. Then all the properties, all the transaction must be registered. If it is not registered, if it is on a white paper, then it will not give any rights on the property to the donee. So, if you are transferring your property to any religious body, to any religious association, you must register by paying proper stamp fees to the government. Otherwise, it is a useless document. Okay? Okay? So some people will have the feeling, hey, it is to an idol, it is to a temple, it is to a church, it need not be registered. Wrong. Whatever may be the transaction, if you are transferring to any legal entity, it must be registered. Okay, so there are plenty of such illustrations. I have given only 2 illustrations.
So,
Yeah.
so the juristic characteristic of idol makes it a legal person. That's why
Yes.
we do the registration, right, sir?
Yes.
Okay, sir.
Yes. Okay, so what we have understood under section 123, if it is a movable property, a simple transfer, a simple delivery of the possession of the property from the donor to the donee will be a valid transfer of gift in case of movable property. In case of immovable property of value of more than 100 rupees, okay, it must be by means of a stamp paper prescribed from time to time by the government. It must be registered with the jurisdictional office of the sub-registrar by paying the governmental fees. Okay, only then it is called as a lawful transfer of gift. Otherwise, it do not have any value in the eye of law. Okay, section 123. Why I have explained this section is they will ask you the question, how gift can be affected, how gift can be transferred. So simple words, you can expand these 2 points into 1 page by giving illustrations. You must develop the ability to create your own illustrations. Imagine and create. Okay? Yes.
If you don't mind, can I just add a point, sir?
Yes, please.
Yeah, sir. Actually, I have books for that, like old books of property law. And in one case, sir, the case name is Sainath Mandir Trust versus Vijaya, AIR 2011. Sir, in this case, the judgment given by Supreme Court was that it said that as a property, suit property was dedicated to a deity, that is the idol.
Okay.
So it did not require registration. And also because it constituted a religious trust, gift to an idol may be oral. It may also be affected by an unregistered instrument.
Oh God. It's very horrible, ma.
And
It's
this
very,
is
very horrible.
2011 case. That's why I was like, actually, I had a mood. So I remember this case. I was just not getting.
So bad, so bad. Okay. So send me the details to my WhatsApp.
Okay,
Okay,
sir.
but it is very, very wrong judgment.
Yes, sir. Because
Then if that is allowed, so many problems will rise in this country, which is already with lot of so many problems.
Actually, sir,
No,
it's a
no.
para. I will just click a picture and I'll WhatsApp you. Also, the case name also.
Huh.
In this para, it talks about three cases. First
Uh-huh.
case, it says that they are juristic persons. Hence, we have to register document.
Hmm.
Then, in another case, that is of Madras High Court, that is Narsimhaswari and Venkatalingam. It says that it
Hmm.
is not a living person. It is a gift to an idol. So
Hmm.
registration is not necessary. And again, in 2011 judgment, it says that yes, it can be oral,
Hmm.
and we don't need any kind of registered instrument. It can be affected orally. It can be affected with unregistered instrument.
Oh God, that's very bad. Okay, very, very bad. Law in our country is already weak,
Yes, sir.
and we are going to destroy even the weakest law. That's very bad. Hmm?
Yes, sir.
Yeah. Okay, section 123, that much is enough. We will go to section 124. Now, you tell me how many kinds of uh, people are there who prizes you always? Is there any people who always prizes you?
Surprises you means I did not get it.
Prizing you, ah, you are great, you are wonderful, you are everything, you are Indar, you are Chandar, you are queen. So
No
many
one,
such
sir.
words.
Sir,
हैं?
no one, sir.
क्या बात है लविन?
Honestly, sir, no one.
What is this? You don't have even one who prize you.
No one, sir. Actually, sir.
Acha, acha, acha. Oh, I
I
think you.
personally feel like only sometimes you are the only one who says, okay, very good. Then I feel appreciated or praised.
Arey yaar, you look like, I don't know, I have not seen you, but you may be like Dhara Singh. So many people are afraid to prize you. वो
Not
बात
like that, sir.
क्या? बात वैसा है क्या?
No,
No?
sir. No, no. Like,
Yeah.
and
Now.
sir, in today's times, I don't think personally, like, if people are afraid because of to make any comment
Hmm.
on some person uh, on the basis of their physical appearance, like they really don't care. Like if a person is huge or small or like they are everybody feels free to say or make comments whatever they like. It hardly
Okay.
matters what is your physical appearance and all.
Ah. You know, honest appreciation and fake appreciation. Honest appreciation and fake appreciation. If some people wants to take benefit from you, they will boost you. They will keep you on a high pedestal, saying, "Arey yaar, tum to mahan ho." Okay. Now, let us understand the gift. Is it a valid gift or not? Under section 124, I'll give you two illustrations. You know, the present day, pyar vyar, you know, the young minds, they have this feeling. See, whenever there is an affectionate affair with the two persons, one person will try to boost the other person, saying, "Oh, yaar, you are like that, you are like this, oh, you belong to this family, oh, your father is." So many things they will speak because they want to get benefit from you. Now, one fellow says, "I'm going to build a Taj Mahal for you. You know how much I love you because I don't have words to express my love to you. I'm going to build a beautiful Taj Mahal for you. That big, bade dil wala hu main." You know, some people will say. Now, one person says, "I'm going to execute a bond paper, a stamp paper, that I am going to build Taj Mahal and give to you after 5 years." Today he will execute an agreement. Today he will execute a deed. Now the question is it a valid deed or not? So some person is promising to build something big on a future date, and he wants to make it as a gift deed. A simple thing is it practical? Is it a valid document, or is it a useless document?
So useless.
Why it is useless?
Sir, because in gift the property must be existing, and even both the parties must also be available, that is the donor and the donee. And it should be done in the existing property, like any kind of movable property or immovable property, it must be in existence. It doesn't talk about anything of future nature, like future property, I'll do that or I'll not. It will not consider like that.
Very good. So, whenever we speak about the topic of gift, there must be two parties, the donor and the donee, and the team and the subject matter must be in existence. It must be present there. It should not be a future property. It should not come into existence on a future day. No, that is not. That is not a valid gift. So whatever properties are there in today's world, and the person who is absolute owner of that property, only he has the power to make the transaction of gift. And if he thinks tomorrow I'm going to be rich, day after tomorrow I'm going to build houses, and day after tomorrow I will gift you so many things as today I will execute. The law says no. It don't have any value in the eye of law. Today are you the owner of this property? Today do you have love and affection towards the other party? Today you are going to prepare the gift deed on the proper stamp paper? Yes, go ahead. You can register it and it's a valid gift deed. But if you want to register a gift deed about a future property, it is void. It is useless. Okay, so an illustration may be asked like this. So this is section 124. Okay. Now section 125 about acceptance of the gift. I two schools of that is Dhayabhaga and Mithakshara. Acceptance according to Mithakshara must be made, must be expressed by means of the donee. And in Mithakshara, if he rejects, yes, it will not be a valid, it will not be a gift at all. Okay. Now let us take one Mithakshara family. One Mithakshara family. There is Mr. A. He wants to gift 5 different houses in a single gift deed. 5 different houses in a single gift deed to 5 brothers. Mr. A is the absolute owner of 5 different houses. He wants to give all the 5 houses in a single document to a family of 5 brothers, and they belong to Mithakshara school. The registration has been made. Out of this, one brother, one of that donee, refuses to accept the gift. Whereas the other four donees accept the gift. They express thanks to the donor. Now you read it, section 125. Gift to several of whom one does not accept. Then what will happen to that gift transaction? Mr. A has made a gift of 5 houses in a single transaction to 5 brothers. Out of that, one brother rejects and the other brothers accept that gift. Is it a valid gift or not? That is the question they are going to ask. So here, the law says, this is an illustration under Mithakshara. There are 5 different donees, and the donees are receiving 5 different properties in a single document. If one of the donee rejects the property, reject the gift, and the other 4 brothers are accepting the gift, then this document, this gift deed is valid. To those persons who are accepting it, and it is not a gift to that person who is rejecting this gift. Very simple. The entire document will not become useless. The gift document, gift deed is valid. It is valid in respect of those persons who are accepting the gift. And it is not valid in respect of that person who is rejecting the gift. Okay, so one illustration from this section 125. Please ask any question in this if you have a doubt.
No doubt, sir.
Okay. Yeah. Do you, we'll go to the next section, section 126. Do you have any stories of your childhood friendship when you are in 2nd standard, 3rd standard, 4th standard? Or do you have any story of your childhood friendship? Do you remember any such child friends?
Yes, sir, but which kind of story you are talking about?
अरे बताते जाओ ना यार, बोलते जाओ. Think of your 2nd standard. Think of your 3rd standard. How were you? Who was your best friend? Have you fought with him or have you fought with her? Have you lost that friendship? Such stories will refresh here under section 126. Law has to be remembered with your life, otherwise it will be dry.
So none of my childhood friend is my friend still.
Sir, I have a story.
Yes, please.
Actually, there was one friend of mine, and I was in 1st standard. So his family moved to my city from Bhopal, Madhya Pradesh. His father is a government officer, income tax officer. So in the month of August itself, it was his birthday. So he invited me over his house for his birthday party. And when the party got over, so his mother gave me a set of sketch pens.
Oh, yes.
So I was shocked. I said,
Hmm.
"Why are you giving this to me?"
Hmm.
So no, I actually approached my friend and said and asked him, "Your mother gave me this thing. Why? It's your birthday, so I got a gift for you. So you should be the one getting gifts." So
Yeah.
then he told me, "This is a
Hmm.
return gift." So at that time, I got to know there is a something called return gift also, and this was the thing, sketch set of sketch pens which I got as a return gift, and
Oh,
there was a
yes.
one coconut chocolate
Huh.
attached to it.
Oh,
So
yes.
that's
Wonderful
just
thing.
short story.
Yeah, yeah. That's really good. Good, good, good. Okay. Now, let me tell one small story of a poorest boy. You know, India is a land of villages. All persons are not rich. Majority of our population suffering with poverty. Consider there is a governmental school. There is a boy, maybe in the second standard. We will call him as A. And there is another boy, B. This boy, A, one day, he had a chocolate. You know, when they find a chocolate, they think that they are like, they are finding heaven. That much of value they give to that piece of chocolate because they never tasted it. So consider one chocolate. Mr. A, that boy, that small boy is having. And you know, he brought it to the school. And in the afternoon, he opened that, he showed the chocolate to another friend B. And he said, "Can we share?" Then A, without any bad feelings, he just, made a piece of it and gave it to B, another boy, and say, "Arey yaar, kuch to kha lo." Then both of them ate small piece of chocolate. They divided the chocolate, they ate it. You know, all the days will not be the same. Time will pass off and the relations change. After 6 months, suddenly both A and B, who were very good friends, they started fighting. They started fighting for some matter, and from that day, in this fighting, A asked B, "Arey yaar, that day I had given you that piece of chocolate, no? You don't want my friendship. Now come on, you give me back that piece of chocolate." Now you please look at section 126. Read that section.
When gift may be suspended or revoked, the
Revoked. That means, can you gift something? Can you take it back? When can you take back? You know, if you are civilized, whatever may be the gift, whatever may be the friendship, whatever may be the relationship, once you give the gift, there ends the matter. You don't have the right to suspend it temporarily, or you don't have the right to take it back. So section 126 says, a gift is always a gift. Once the gift is made, the donor is going to lose ownership in the property, and the donee is going to gain ownership in the property. So the donor, once he passes the property to others, he loses ownership. He don't have the right to temporarily take back or to take back permanently, completely. That is the most uncivilized behavior. So 126 says, no, you cannot take it back. It's void. It is condemned by the law. So I request all of you, if you have given the gift to others, give the best possible thing within your limits. Once you give it to them, never even think of taking back the property, even if you become enemy to that person. So once over, it's over forever. Here section 126 says, there are two circumstances where the gift, once given to others, can be taken back, can be restored back. The donor will receive back the gift. The donor will receive back the property only in the following two circumstances. So what are the two circumstances? So let us analyze. Number one, on the happening of a contingent event. You know, if a gift contains a condition of a future event, future happening, and such future happening is not in the control of the donor, then if such an event takes place, then the donor can take back the gift. Now let us go to our India to the days of British rule. There were two kinds of politicians in those days. One was peace-loving politicians, and the other violent politicians. Peace-loving politicians, they never wanted to fight with violence. But the violent protesters destroying the property, were killing the people, killing the British officers, killing the British governmental servants. So there comes Chandrasekhar, Azad, Subhash Chandra Bose. They were the violent freedom fighters. And the peaceful politicians, they were always obeying the law and opposing the law and telling the Britishers to go away from India. So let us take one illustration. Okay? Carefully keep it in mind. We'll call Mr. X. Okay? I have not written in my notes. I have read long ago, so I'm telling this to you. One X is a zamindar, is the owner of some acres of land. He is 25, 26 years of age. Very violent freedom fighter. Very violent. He has killed many British officers. One day he was caught. He was caught and he was found guilty, and he was given a punishment, that is, the life imprisonment in the Andaman Nicobar Island prison. So he was, this man was given that sentence of life imprisonment in that Andaman Nicobar jail. And he was given some time in this, in his town, saying, whatever work you have, you can finish off your work. We will give you 15 days of time. By the time we have to take you. So this man, he is the absolute owner of some acres of land. He had a brother. And he prepared a gift deed in favor of his brother, saying, my dear brother, I'm the absolute owner of this property, and this property shall be yours from this moment. You use and enjoy the property according to your own whims and fancies. But my dear brother, by the grace of God, if I am let free by the government, if I am excused by the government, then I'll come back to this village. I request you, if I come back, you must return the property to me. So this is the condition mentioned in the gift deed. And it was registered. So A has transferred his property by means of a gift deed to his brother with a condition, in case of his returning to this land by the grace of the government, the property must be returned. This is the condition. You know, in those days when the mainland prisoners, means from our main Indian geography, the prisoners were taken to Andaman Nicobar jail. There, they used to die in the jail. Majority of them have died. They languished in the jail for many years, and they had the last day also. Now consider to this illustration. Consider this Mr. A was taken to the Andaman jail. He was kept there for 10 years. On the 11th year, India got independence. India got independence. And the government released all the freedom fighters. And Ye comes back to his hometown. Now you tell me, he came back to his hometown empty-handed. He don't have anything. Can he take back the property of gift from his brother or not? Come on, tell me. What happened? Can
Sir,
he
I
take
think
back?
he can take back.
He can take back. Remember, the release of Mr. A from the jail, is it under the control of the Doni?
No, sir.
No. So, that event, whatever agreement they enter, whatever condition they enter, there has to be a future event, and that event should not depend on the will of the donee. It should be beyond the control of both the donor and donee. Only then such kind of happenings will be considered as valid, and the donor has the right to take back that property. Okay, he can revoke that property. Right? Got it?
Yes, sir.
Now we will go to the second condition. Second circumstance where you can take back the property. You have studied Indian Contract Act. You have studied free consent. You have studied, is it not?
Yes, sir.
Yeah, what is consent? What is free consent? What is consent? What will be a free consent?
So consent basically means agreeing on certain or any contract, and free consent
Yes.
like he is not under any pressure or not being coerced or being frauded or he's not under any undue influence, something like that.
Yeah. Good. So, every one of us have a sound mind. We have a thinking capacity, a judgment capacity. We know the right and the wrong, bad and the good, false and the truth. So, for every act which we do in our life, we have to do it voluntarily, out of our own wish, will. We have the freedom to do it, and there should not be any element of compulsion, force, pressure, or any kind of brainwashing, any kind of mistake, any kind of fraud, any kind of misrepresentation, any kind of coercion, fear, pain, benefit, any such things. If any one of these elements are present, then such a transaction is considered as void, and it loses the validity of the document. So in every gift deed, the donor must transfer his property to the donee freely, voluntarily, without any kind of coercion, fear, threat, etc., etc., etc. If the donor proves the presence of even one element, then the court is having the power to accept the challenge and to cancel that deed of gift. And the property will come back to the donor. Okay? So if you have studied contract number 1, there is one wonderful old case. Then the case is called Manu Singh versus Umadat Pandey. Sometimes I'm very harsh. I hate the dirty people of this country. I hate the parasites of India who are sucking the blood of the people. Do you know in Haryana there is last year he was in the news. One Paramatma, one religious man.
So that messenger of God.
Messenger of God. So hero like admi, है ना?
Yes,
Very
sir.
tall, built, और Punjabi body है. See, from Kashmir to Kanyakumari, wherever you go, you find these rooks. They are the religious leaders of this country. They have different gobs, different makeups, different dresses. And they always attract big people, people with money, and they never attract poor people. Remember the secret. They always attract big people with big money. They do all kinds of nonsense things. And they want to grab the property. And after grabbing all the property, they will ditch those persons. So here is a case of one such a dirty, parasitic, religious people of this India. Manu Singh versus Umadat Pandey, 1890. You know, we the ordinary people, we work sincerely, honestly. We earn our livelihood. And we are the real religious persons. Whereas these so-called religious persons, they always suck the blood. So in this case, Manu Singh was sufficiently a rich man. He had a wife, he had children, lot of property was there. And there was a Swamiji, Umadat Pandey ji. And you know, there was an ashram. Nowadays, these people are a big mafia. They have occupied so many acres of India. I don't know when justice will be done on them. When they will be taught a lesson, I don't know. I don't have that bright thinking on our country, on my country. So one day what happened? This man is around 65 years of age. And you know, I don't know what happened. He started attending the discourses by this Swamiji. And you know, so many Swamijis are very good speakers, very good attractors. They mesmerize the people. They mesmerize us and they take what they want from the disciples or the devotees. They will there is a man, rich, money, and he was attracted to the Swamiji. And Swamiji started teaching him, "Arey yaar, I will show you the path of heaven. There you will be surrounded with beautiful people to serve you. But one thing you have to do, I can take you to the path of heaven. First, all of you must shut down your properties, luggage. It is a luggage. It is a burden on you. Come on, you give it to me. I will remove that luggage from your path. Then I will take you, lead you to the heaven." And they were teaching Bhagavad Gita. Jai ho Mahan hai. So, time has passed. The relatives came to know about it. His family came to know about this kind of deed. And they all tried to advise this old man to make the changes or to file the case and to get back the property. And the case was filed against the Swamiji. And here the court asked Swamiji, "You are a Jagat Guru, you are a Swami, and you have that capacity to mesmerize your devotees. You have the capacity to brainwash the devotee's mind. You prove that you have not influenced the mind of your devotee. You prove. If you disprove that you are so good, so honest, so sincere, that you have not applied any kind of undue influence, then the property is yours, Mr. Swamiji. But the court proved the presence of undue influence on the mind of this old man, was brainwashed by the Swamiji. And the court accepted the proof of it and cancelled the gift deed, saying, here is a gift deed made by Manu Singh to the Swamiji, not voluntarily, not freely, but out of undue influence. So the gift deed was cancelled. So this is the second circumstance where the gift once made can be revoked, can be taken back by the donor and his families. Okay, yeah. Any questions here?
No, sir.
Okay. Now I need 1 more hour. Next hour, I will finish the remaining, some few topics are there. 1 hour I will finish. Then Hitesh has told me, you commence criminal procedure code. And the next class I will, after finishing this one, I will commence CRPC. Okay?
Okay, sir.
Yeah. So if you don't have a question, can we wind up here? Enough
sir,
for
we can.
today? Okay?
Yes.
Yes, sir.
Okay.
We will take the next class, sir, next week.
Next week, Tuesday, no?
Okay, sir.
Okay. So we will have the
Yes.
same timings. Same timings. We will sit, and CRPC is very, very heavy, very, very bulky.
We will take CRPC also for us.
Yes, ma. You talk to Hitesh today, okay, or tomorrow, all of you.
No, I don't want to talk. It's good you are taking. I enjoy your class.
Actually, sir, I'm also happy
I
that
am
you are taking
happy listening
CRPC.
that you will take my CRPC, because in my
Same
college,
here, sir.
the way I have read CRPC, I just hate CRPC.
Arey yaar, huh?
Seriously.
Same with me, sir.
Huh.
And that too, sir, KSLU student. How much I will write, then also I'll get that much marks only.
You are
So there is
unlucky.
no- so I just used to hate CRPC.
You are unlucky you joined KSLU.
Yes, sir. 5 year wasted.
I request you, please suggest to other people not to join KSLU because you suffer, you suffer, you suffer.
Upper means, like, we used to literally struggle to get 50.
Ha,
Like, mark sheet has come and all the 4 subject 40. I don't know
40.
how come. 40.
Yeah, they're all doctorate people, the teachers with the doctorates, and they think that you are inferior and they don't want to give marks.
And that too, the worst thing which I heard about KSLU, which literally I came to conclusion I will never ever suggest anybody, is a few of our teachers said that, like, if, for example, I am a constitutional teacher,
Okay.
so I may get papers to correct of other subjects. What is this? If I am constitutional teacher, you give me to correct constitution? No. Why you're giving me CRPC, CPC? How other teachers will know?
Yes, yes. Yeah, unfortunate. Okay, unlucky fellows you are. So don't join. Join any other university. In
Now
India, we have plenty of universities. Okay, so kindly join others, but never tell any others, suggest any others to join this, because you ruin your life.
Correct, sir.
Okay, okay, enough for today. Okay, good night.
Thank
Take
you so
care.
much, sir.
Take
Sir,
care.
happy Independence Day in advance.
Yes,
अरे
sir.
यार किसका इंडिपेंडेंस डे है यार
Lavin, you are wishing Pakistan
No,
independence.
I said in advance.
Advance. Yes. Good. Okay, let's be happy. Hmm?
Yes, sir.
Okay.
Yes.
Okay. Good night.
Good night, sir.